Hello and good evening and welcome to another program on law and order. In this program, we discuss different types of law. And as you know, law is divided into so many different areas. Today, we are going to touch upon a type of law which is hardly spoken about, and we in this program have not dealt with it before. The area of law is called public law. And to discuss this, none other than a specialist in this area I invite, and that is Rajiv Amarasuriya, attorney at law, and he is my guest today to discuss about public law and other areas of law that is related to. Rajiv, welcome back to the show.
Thank you, Chanak.
How are you doing?
Nice to be back on this show.
Public law, wide area, and I think very few people in the public knows about this. Give me an explanation or definition of what exactly is public law.
Well, as you rightly said, it's a very vast area.
Yeah.
It is actually, Chanakya, the law which governs the relationships between the private citizen, the private individual, and the government. And also the law which basically governs the structure and form of government. Now, public law can be divided into three fairly large areas. That is constitutional law. As you know, that is the law which deals with the legislature, the judiciary, and the executive, and the interrelation between those three organs of government. Then criminal law. I mean, I don't need to explain what criminal law is. We all know what criminal law is. And also the third area, administrative law, which I'm actually more involved with. Administrative law deals with, again, the relationships between the citizen and agencies, the executive branch of government. To simply put it, that would mean now, even on a day-to-day basis, we as citizens, we have relationships with our government, we have with our local authority. They have to collect garbage. I mean, we have even from corporate level, you have licensing. So all those are areas which come within the purview of administrative law. And writ applications, which we'll be looking at, I think, later on, comes within the sphere of administrative law. So that is how public law is basically, these areas come within the realm of public law.
So now, does public law has a part in all the areas of law? Is it like connected in some way or the other, isn't it?
To some extent, yes, because I mean, all these, ultimately it's the same fundamental principles which drive all areas of law.
Correct.
These are now over years, these little sub areas have formed. But I would say, yes, there are interrelationships between other areas as well.
Right. Now, the public law in this country, where did this emanate from? Is it a mixture of the Roman Dutch law and the British law?
It's mostly from English law, I would say, because now public law has, apart from the three areas I spoke about, also within the administrative sphere, we have the fundamental rights jurisdiction. We have discussed this on a previous program. Now the writ law emanates mostly from, or derives its source from English law. It was actually you had something called prerogative remedies in England. That was where this is before the 16th century, where there were state bodies which were exercising power, and the monarch, whenever he or she wished, sought intervention of court through prerogative remedies to ensure that those public bodies, public authorities, public officials worked within the framework.
Right.
Now, the parameters of their authority.
Yes.
So
that can be said as the intention of public law. Can we say that?
Certainly. Yeah. The intention of public law is now a vast area of government. So within the government there are various powers which emanate. Actually, a lot of the power emanates to the constitution, and that is delegated to various branches. So each from the top to the right to the smallest officer, they would have their parameter of power or authority. So if one steps outside that, from a very basic standpoint, then that would be what we call ultra vires. Of course, that is in a very simple form.
Simple form.
Of course, public law is much wider in scope and ambit.
Right. Now, before we go to other areas, now, if I may to look at this public law, is it the same, the principles, in all countries that have a democratic governing system?
It is not identical in the form of implementation. But I would say that the fundamentals are very similar. They arise from the various the human rights, the Universal Declaration of Human Rights. So those are the various sources from which the rights emanate, and also from a public law standpoint, administrative law standpoint. Basically, all these governments have to function in the same way. But we, especially in the writ law, we rely heavily on English law principles. But of course, having said that, in the last, I would say, 20 to 30 years, the law has developed on its own even in Sri Lanka, and we also now rely on Indian judgments, especially in the area of public interest litigation. I think under Justice Bhagavati, who passed away recently, he expanded that scope, and we have derived, say for example, precedent in public interest litigation from India. Similarly, from England, we have the basic concepts coming, but organically, even here, we have developed. It has developed over the years, the jurisdiction.
Right. Now, just touch upon probably my next question: public interest litigation. It is a growing area, I think, in Sri Lanka as well as in other countries, but probably not as much as in other countries. What exactly is public interest litigation?
Usually in any court, as you know, you need to have standing, locus standi. There has to be you have to be aggrieved, or you have some grievance to go before court. Just a citizen on the road can't say, well, there is this happening, I want to invoke the jurisdiction of court. Now, public interest litigation is a concept which actually which developed where, more so in the Indian courts, where the courts permitted citizens to come on behalf of the public interest. And to that extent, if a citizen was able to come before the court and say, well, there is this issue, there is this serious issue which is affecting the public, I am not directly affected, but as a group we are affected. Then the courts actually dispense with the requirement of having particular standing, and they permitted these citizens to come forth. And actually, it was very, very progressive, because it allowed actually. Sometimes the citizen who is directly affected by certain action may not have the resources to invoke the jurisdiction of court, or come before court. Maybe they don't have the time, maybe they don't have the resources, or they may not have the expertise. But that made way for actually groups of citizens, we call these NGOs, various public interest groups, to form together, come together, and then fight for these public rights. And it has been very progressive. But having said that, as much as there is a positive, there is always a negative side also. So sometimes we have seen over the years, many jurisdictions where public interest litigation also sometimes could be abused.
Could be abused.
For various other reasons, people will come and say, well, public interest, but if you really drill down, the motive might be something political or something, some private interest coming up. So, of course, the courts have discussion, and the courts upon application in public interest, courts can determine whether actually this is a public interest application.
Okay. Could you give me two examples of that, if you know, from any place in the world, about the genuine public interest which came up and where it was attempted to be abused?
Well, we have had several cases in public interest litigation which have actually
really helped that
translated into, take the Water's Edge case.
Right.
This group of citizens came before court, and after so many years, and they took up the position that the whole transaction was flawed, and the court finally upheld those arguments. Then Sri Lanka Insurance, Lanka Marine Services. So those are cases where actually, then I think various from wildlife, the Bilpat, when the various cases which have been filed, and they have actually resulted in some positive determinations by court. But of course, offhand, I've come across cases where I have appeared for respondents where I have taken that objection, saying that, well, there are verments in the petition saying public interest, but this is certainly not public interest. This is to do with private interest, and so you can show it on their own documentation. So those cases sometimes don't get off the ground because of that. but then basically offhand nothing really, and it's not fair to also mention cases.
Internationally, have you seen where it has been really successful?
In India, there were various, pollution cases, then also this trans-border pollution, things like that. In India, it's very been made use of a lot by the Supreme Court lawyers based in New Delhi.
Is there any changes you think that should be done in our legislature to strengthen the public interest litigation? Or is the mechanism
This is a mechanism of court, which actually I would think the discussion must be kept to court. Because you can't really formulate guidelines for an area which evolves with time. This is something which has to evolve. There may be times where the courts must be conservative. Because otherwise, if you set out a set of rules, then you'll have, we as lawyers will look at the rules and try to find ways of, so that may not be the spirit in which one must look at public interest litigation.
Right. One of the areas that people always complain, probably to you, to me, and most of the lawyers and any forum, is that lost delays. Now, lost delays has become like a commercial term, right? But the grievance is there. Lost delays means the cases are getting delayed in coming out. What do you see in Sri Lanka for the reasons for the lost delays in the areas you practice, as well as in general in other areas of law?
Yes, lost delays is something, it's now become a term of art.
Yeah.
For lawyers, for politicians, for anyone who writes an article about the legal system.
Yeah.
First, from the point of view of the area I practice in, which is public law, from the civil side, I wouldn't say that it's too bad. Because now the writ application is in the Court of Appeal, which is the second most superior court in the country.
Yes.
There's only one appeal and it finishes very fast. Fundamental rights is before the Supreme Court itself.
Yes.
Now, one reason for lost delays is that you start with the district court, you take 10 years, another 3-4 years in the High Court, and the Supreme Court, when you add the number of years, it's a very long period of time. So, but having said that, even in the public law area now, several years ago, in the writ court, I just take an example.
Yes.
We had about maybe 4 or 5 years ago, we had about 2,000 cases filed in a given year. 2,000 new applications, and that is very simple to verify. You look at the case number.
Yes.
And by about December, you're hitting 2,100, 2,200. That is not the case today.
Yes.
Numbers have reduced substantially. You have two courts looking at writ applications. So physically, and you have probably about 200 days in the year.
Yeah.
So if you have 2,000 cases, 2 courts, and just 200 days on basic simple arithmetic, it is not difficult to it is not practical to conclude.
Yes.
But having said that, I think the judges have done a brilliant job in trying to manage the resources and have actually managed to not make it get it out of hand. But now from a broader perspective, actually I was on a delegation. I was a member of delegation of the Bar Association about that was in 2000, if I'm not mistaken, 16 or I think last year, where we went to Singapore and Malaysia to study the system and to come out with or figure out how they resolve this matter.
Yes.
Something which I as a member of the delegation, which I realized, which all of us realized, was that this problem we have today is not singular to us. This is a problem which even Singapore, Malaysia, which they faced 15-20 years ago. The difference is that they have now to some extent resolved it, especially in Singapore. I think there are some issues in Malaysia where there is, I think the mechanisms they have put in place may not be may not have reaped the results as they anticipated. But from Singapore's point of view, they have this system of case management,
right,
which is very important.
Yeah.
That in fact they have a regular judge, say take for example the level of a High Court judge, who for a year or two is allocated the job of only managing the cases.
Right.
So he doesn't sit in, he doesn't hear cases.
Yeah.
His job during that year or two would be to basically do the job of what the registrar does in Sri Lanka.
Yeah.
And also there is, before the case, there is case management where you actually meet. Now, for example, in Sri Lanka, we meet the opposing counsel in court.
Yes.
And we go at the bar table. But here you would meet your opposing counsel before. You would both parties would discuss as to how long the case would take, how many hours you need, what is the documentation, and also fix the date of the case mutually. So you would have, they would have a plan. The plan of, or the time plan would be preset.
Right.
So which means that then when the court has to allocate other cases, they know, well, it will take 2 hours or 3 hours on that for this case. Then the next case will be fixed thereafter. And also, once you fix the case, it's very difficult to postpone.
Yes.
You can't come and say you are not ready. You have to be ready.
You have to be ready. Yeah.
So basically that aspect of case management.
Yeah. No, the lawyers also get to know that this is the time allocated, and they get to know in advance, right?
Yes, and it's mutually discussed.
Mutually
discussed. I need 45 minutes, I need 1 hour. Yeah. I mean, you can't say I need 2 days.
Yes.
I mean, of course, depending on the matter.
Yeah.
So then there's the judge who will basically, it's more like arbitration.
Yeah.
They will discuss and have an agreement.
Yeah.
I need so much, you will need so much. These are the documents we will present, and these are the date on which we will take it up. So that way, there is also, from the point of view, the lawyers, Chanakya, sometimes, you would know, sometimes the litigants might say, well, the lawyers are delaying cases. That is not the case.
Yes.
We actually know when we go for a matter, and the matter gets postponed,
yes,
we have spent the whole day evening before that studying that case.
Exactly.
And we have burned the midnight oil,
Yes.
gone through, then you go through, and then if the matter is not taken up.
But the blame directly comes from the client to the lawyer.
That's the problem.
Yes.
So, and then the lawyer has to then again study the same case 3 months down the line.
Exactly.
And with your other work, I mean, it's not something which is at the top of your, mind. So you have to go through the papers again.
Yes.
So actually, if a matter, and even from the point of view of the judges, they will come prepared the night before, or the day, few days before.
Yeah.
And when the matter is not taken up, it's a waste of time.
Yeah.
And then time spent on preparation.
Yes. So you all did a study and you suggested
Yes.
recommendations.
So we have submitted a report to the Bar Association. This delegation was led by the senior lawyer, Mr. Anand Vikramasekara, President's Counsel from the Gaul Bar, as member of it. And a very comprehensive proposal was submitted. And I think the Bar Association is looking into it. And of course, we have to have a common effort from the judiciary, from the lawyers ourselves, and also from the state to support some kind of development.
Right. Now, but if you look at present day, I know there are the provincial high courts, provincial civil appellate courts came up, and that reduced a lot of work, and it was fast tracked in that area of law. Correct me if I'm wrong. And but still, people are complaining on that. Now, despite making these recommendations to the necessary authorities, what is still making a case take so long? Especially if I may add to this, if you look at the immediate regions, like if you look at in Colombo, at least if you look at the district court, there are several district courts, and there are other places in the country where one particular district court or two has to handle all areas of things. Is it the lack of courthouses? Is it the lack of staff? Is it the lack of government funding? Or is it, what do you see? Now the mechanism you have suggested, this is the way to go. I mean, you all have done detailed study, but still it is not happening to the expectations.
Well, you can, I think there's a proposal in the Constitution to increase the number of judges and all that. Well, you can do that. But I think substantively we need to improve the quality of the entire system. The lawyers, the judges, the court staff. I mean, we must be more result-driven, result-oriented.
When you say result-driven, what do you mean?
Because now even even in all these spheres, I mean, it must be a merit-based system. I mean, you must have performance. You must have performance evaluation. Now, for example, a judgment. If a judgment of the district court, I'm not trying to find fault with anyone, but if a judgment of the district court after 10 years, and if the judgment is overturned twice over in the High Court and the Supreme Court, I mean, obviously that should not happen. I mean, we should have situations where now the whole problem is now the Supreme Court sometimes a lot of applications come up in appeal, lot of matters. But ideally, we should have a situation where the district court or at least the High Court, at the High Court level, the matter ends. The parties must accept that judgment. And then if that happens, the number of cases will reduce. So we need to have.
But what can you do if your client still says, no, I am not accepting this judgment? I mean, isn't it beyond lawyers and judges?
Well,
how fair the judgment is?
yes.
Yeah.
Of course, the Supreme Court on in the appeal, the third appeal or second appeal, it's not as of right. So they have the discussion of refusing, and that is what takes place. Sometimes it's very clear judgment, but and also I think the courts also must take the position that when these frivolous applications are filed, you must order heavy costs. So that should be a deterrent. If someone is going before an appeal, you must have at least a 50% chance, or even a 40% chance of success. But with 2% of 3% of chance of probability of success, you should not be appealing. And in those appeals, you must have heavy costs, so that litigants know, well, it will be a costly exercise.
So what you're saying is this multiplicity and frivolous re-litigation or appeal and litigation adds to the delay.
Certainly,
that's the volume.
The court has to go through that process.
Yes.
So certainly, and we as lawyers, and a principle I follow is if the case is not good, I mean, I certainly don't take the brief.
Yes.
There should be some possibility of sustaining it. It's not fair by the litigant. It's not fair by the court.
Right.
So I think we as lawyers also have a responsibility in that way.
Right. We discuss a lot about loss delays and public interest in public law, and one of the areas of public law is writ jurisdiction or the prerogative writs. And I know we will discuss it later, but in this program, can you tell us in brief what is the writs in Sri Lanka and the prerogative writs and the remedies available? Can you give me a brief introduction?
The prerogative remedy was the remedy available to the Crown in England to invoke the jurisdiction of court to ensure that inferior tribunals and public officers, authorities work within the parameter of their authority.
Right.
After about the 16th century, this right or the remedy was made open to citizens to invoke the jurisdiction of the King's Bench division of court in the name of the Crown. So this is where the writ remedy actually derived the source of it. In Sri Lanka, it comes under Article 140 of the Constitution, which specifically provides that the Court of Appeal shall have jurisdiction to examine the records of inferior tribunals and other agencies of state, and then call for the record and then determine whether they are within the framework. They can issue several types of writs, writs of certiorari. Then, of course, mandamus, you can compel public authorities to perform their public responsibilities, prohibition, quo warranto, so on and so forth. So, and also with the Provincial Council, the 13th Amendment, a part of it, the powers which comes within the Provincial Council list was, there was provision made to bring that area within the Provincial High Court. So if someone is aggrieved by a matter coming within the Provincial Council list, then the litigant can go before the Provincial High Court and seek the writ remedy.
Okay. And these remedies are taken against action of the state?
Yes, mostly it is a state, but there is the Lord Atkins formula, which in the 1920s, which has now developed. It is action of those who control or who make decisions affecting the rights of citizens, and who are in control positions. So sometimes it may not be directly a state institution, but you might have, like, say, a stock exchange making a decision. There are judgments where the writ application has been invoked. Then you have private banks with parate execution rights.
Yes.
The court intervenes. So there are instances, sports bodies which have controlling power over its the people it controls.
Right.
Then the court has invoked. So it's a little wider than the state also sometimes.
Okay. Now this topic is a vast topic, writ jurisdiction, and we're going to discuss this in detail, Rajiv, in our next program. So you stay tuned for our next program where we're going to bring back Rajiv and we're going to discuss more detail, deep into the subject of writ jurisdiction, prerogative writs and remedies available on that. But for Law and Order for today, that's it. Rajiv, thank you for joining us and for those valuable thoughts. And we'll join you next week at the same time. In the meantime, you can go to our Facebook page. That's Facebook/Law and Order Channel I, Facebook/Law and Order Channel I, and post your comments or queries, and we will take them into consideration. Enjoy the rest of the programming on Channel I and have a good weekend.